All right, so this is the second part in the series of constitutional review that we are about to cover in the second half of this semester. Right. So in the last video, we talked about uh, the nature of the judiciary, like the idea of impartiality, the idea of professionalism, the idea of judicial independence, and how these features set the judiciary apart from from their political cousin, their compatriot, right? So today we're gonna focus specifically on the idea of constitutional review. Right? So let me turn on the slide. I hope you all have access to the last video with very little trouble. Okay. So here, uh, today we're going to talk about a constitutional review body, right? So in our last video, we talk about accountability and how accountability contribute to trust in the government, right? And how trust contribute to the survival of democracy. And and so accountability is actually very important. And one way to enhance your own accountability is to limit or restrain your own conduct within certain framework, right? So the idea is that you cannot exercise your authority in an arbitrary manner, right? So that is what a modern government is all about. That is what constitutionalism is all about. Limited government. Right? So yep, you are appointed to a public office. You are given immense power, but that power can only be exercised within a very specific purpose as agreed in a constitutional framework. So, constitutional framework is the largest framework to govern the conduct of the government. This is the framework that has been agreed upon long time ago between the government and the people, between the rulers and the ruled, right? So, that's a very much the idea. And constitutional review body is necessary here because uh, you need someone to enforce the mechanism, right? If you prepare a very lengthy document, if you prepare a lot of rules and regulation, but you don't decide any umpire or regulator to check whether these rules are to be followed, then your rules become useless. Uh, when you write something like this constitution is the supreme law of the land. I mean, the only way to ensure that this constitution will remain the supreme law, which means like no one can like act or do anything contrary to the constitution. You need a body or the body to be there to regulate and to point out when someone step off the line, right? So that's where the idea of constitutional review body comes from. It become more and more important, especially when I mean in a modern democracy where you have a written constitution and you have really very little customary convention to govern political conduct. So you rely a lot more and more on uh, external body to enforce some rules, to enforce some disciplines upon politicians, right? So we're going to talk about four different models of constitutional review, different models of uh, here it's called judicial review, but you can say it's a constitutional review. too. So you see there are four different models and they are developed at different time, okay, under different ideas, different ideology as well. So there are plus and minus of each model, and that's what we need to discuss. Keep it brief here. Uh, So the very first model is called the parliament model. So you ask the parliament to review constitutionality of their own statute. On one hand, I think that makes sense because if you think about that, when the early Enlightenment philosophers proposed their democratic theory, right? They talk a lot about sovereignty belongs to the people. So they emphasize a lot on the collective body of the people or representative of the people in in that regard, right? Um, so actually they didn't discuss much about cons constitution. They are more concerned about the parliament as the gathering or assembly of people's representative. So when you have a constitution and the constitution in this sense is written upon the agreement or by the consent of the people. This is a form of social contract, right? Social contract theory, Jean-Jacques Rousseau, or even Emmanuel Sieyès. If the law is prepared or agreed upon by the people, so the people or the representative of the people is the best body to review the constitutionality of the law. Right? That's so this model emphasizes a lot on the importance of the people and the linkage between the people and democracy. So they think that because the constitution comes from the people, so the people would be the most suitable one to say what is within uh, outside of the boundary of the constitution. Right? So in the sense, this is you can say this is like the most democratic model. Right? So it is prevalent in, for example, in France after the revolution in their first, second, and third regimes. Right? In Thailand in 1932, right after the revolution, if you look into our early constitution, it would say that the parliament reserved the right to interpret and review constitutionality of the law. Because the law is passed by the people's representative, so who else will have legitimacy to invalidate them? Like no one else, only the parliament. I mean, the parliament is a gathering of the people. If they pass the law, they are at the best position to say what law is or what law isn't. But also, the parliament model come with the downside, right? So if you think about it very carefully, first of all, I think I couldn't imagine if the parliament, who has just passed that statute, would rule that their own statute is unconstitutional, right? It it wouldn't make any sense. I mean, you spend months or even years to pass that law, and within a few months, you say that, oh, right, um, we didn't do it right. I mean, it would be very difficult for anyone to admit that their own work is unconstitutional, is flawed, right? So there's a very practical reason why the parliament model uh, wouldn't work well. Right? Another argument is that this involves time and I mean, this involve more about timing. So they say that the parliament is a social contract agreed upon by a certain set of people, the polity, right? And the law is and the parliamentary statute is also um, another piece of legislation that is agreed upon by the representative of the people. But these are two different sets of the people, right? So I mean, basically, we understand that um, people intend that the constitution gonna last really, really long. I mean, it's a larger framework, right? And statutory, uh, a statute is a minor law. So when you say that and the parliament is a different gathering, a different kind of gathering from the constitutional convention that constitute a social contract, right? Mhm. Because a constitution is a social contract, right? A parliamentary statute is not. It's just a piece of legislation. So actually, there's difference between uh, a constitution and a statute. So somehow the parliament, which has been elected by the people, uh, is a very different body from a constitutional convention, the gathering of the whole polities that draft a constitution. So basically, two arguments. First is that like no one gonna admit their own error. Right? The second argument is that is a different kind of representative of the people. So they might have different ideas, they might have different priorities, have different objectives, and they wouldn't agree upon this. I mean, the parliament is not the people, right? So they they are not able to speak on behalf of the people, on behalf of the constitution. So eventually, I mean, the parliament model just fall out of favor. Um, the third, the third downside of the parliament model is that if you think about the parliament, it's not. I mean, in theory, in the early theory, we tend to see it as like a gathering of like a I don't know how to put it, but this is like where the representative of the people sit and work together, right? But in reality, it become the house of political fractions. It slowly become under control of political parties. So sometimes it's very difficult to say this is a house that represent the people or this is a house that represent political parties. Like there big difference between the two, right? So if you ask the parliament to review constitutionality of the law, actually you are handing the very important power of interpreting a constitution to political parties, not to the people, but to political parties. So that is one another objection to the parliament model. It will not work because the parliament say whatever the dominant parties at that certain times want to say or want to hear. Right? So slowly, people start looking outside of the parliament, right? Outside of the political branch. So we are left with three different model here. I mean, I think it's best we talk about the committee model. This is the French uh, creation in the fourth and fifth republic instead of creating a specialized court. They understand that a constitutional review is not the ordinary judicial process. It it's not like a purely legal matter. constitution is always a crossroad between law and politics. So you cannot simply ask a lawyer to do the job. They can do it uh, very lousily. Constitution is always a crossroad between law and politics. So actually, you need a combination of both law and political experts to do it. I mean, of course, I mean, you try to frame it as a legal question, but on I mean, in the process of adjudicating the dispute, you have to take into consideration the political nature of the dispute as well. I mean, if you imagine like when you ask the court to consider whether the prime minister is ineligible or not, you know, whether the court gonna remove the prime minister. Of course, I mean the question go to the court. It's a legal question. It's a legal process, but at the same time, you know, to remove a prime minister has a very grave political consequence. So you have to understand that. So partly it's a legal process to adjudicate. Partly you need to understand political consequence and you need to negotiate or navigate through a very, very dangerous uh, water. So that's why the French set up a committee comprised of both lawyers and uh, their own president and and prime ministers to sit and review the law, constitutionality of the law. This is not uh, this is not a very widespread model. Let's say I maybe France and some other country under the French uh, colonial influence might have adopted this model, right? But it relies a lot on persons, on individuals who sit in that committee, right? You cannot always guarantee you get a good political leaders who are gonna sit in this committee. I mean, France might be luckier than many other countries, but all in all, I mean, you couldn't guarantee, right, that you're gonna always get a good lawyers and good politicians and sit in this specialized committee. And plus, as a committee, I mean, um, it lacks a lot of fundamental characteristics of the judiciary. Like it doesn't guarantee any independence. It doesn't guarantee any impartiality or even professionalism. Right? So that render this kind of committee maybe sometimes like unfit for the job. You know, it's a very important job. Right? So I mean, these tools, like the parliament model and the committee models, are two of the less popular options for constitutional review. So around the world, I mean, two more popular options going to be like a court of justice and a specialized court. So the big question here is whether you need a specialized court to do a constitutional review, or could the court of justice do the job just fine? Right? And people have different ideas on this. On one hand, this is a more controversial option because you are asking a handful of experts to invalidate the law that has been passed by a representative of the people. So in a way, we are looking at a very anti-majoritarian model, right? You ask 9 people on the bench to invalidate the work of member of parliament who has been voted by maybe like 20 million voters vote for them, and all of a sudden this 9 experts just said no, this is not the law, we're not going to recognize it. So you can imagine a lot of tension could arise in this model, but at the same time it is these are two of the most popular models because it felt that in order to protect the constitution, um, sometimes you you cannot go with a more popular or a majoritarian option, right? So these bodies are trying to preserve some basic principles. They try to resist the emotional whim or the craze of the majority. So, of course, by nature, it's going to be anti-majoritarian, but because they want to preserve something that may need to, like, must not be tempered by the majority at that moment. Right? People can become irrational from time to time. People can get really emotional and make stupid decisions from time to time. And the duty of the court is to be there to resist that temptation, to uh, to uphold uh, something that is more perpetual, something that is more fundamental, right? Something that shouldn't be tempered by the majority. Right? So you see, there's a forever tension in these two models, but at the same time, people think that this is necessary to install them there. Right? The only question is whether you want the Court of Justice to do this job or not, or you want a specialized court to undertake the job. Right? So the Court of Justice, this is more prevalent in the common law countries. So you can see uh, the UK, for the United Kingdom, USA, and other country that has Anglophone influence or common law influence. So the idea is very simple. The idea is that the court is the court of law. So the court, any court, right? Uh, when they want to apply the law, they must have the right to say what law is. So following this logic, the question of constitutionality of the law can be raised at any level of the court. And you can raise it at the court of first instance, and the court of first instance may rule it, or, or you can raise it at the court of appeal, or even Supreme Court. That's the highest court, right? So you can do that. And if the question is not dissolved satisfactorily, it can go all the way up to the Supreme Court. And once the Supreme Court rules on the issue, it's gonna have a binding effect on all the lower courts in that country. So uh, the idea is that there can only be one court. There can only be one court that adjudicate all sorts of dispute. So this is the idea of equality, right? You don't have one court for certain matter and another court for certain matter. You have one court for all. Another argument in support of having the Court of Justice is like you're gonna have a much cheaper model, right? So you already have a Court of Justice, and the Court of Justice is doing the job, so you don't pay extra for this service, right? You just ask the Court of Justice. I mean, a constitution is certainly just one type of the law that the court need to solve among all the all kind of disputes that the court of has to face in their job, right? So that's the argument for the model of the common court or the court of justice. Of course, the downside, if you imagine, if you can raise a constitutional issue in any level or any court, then you're gonna have a a very fragmented uh, jurisprudence, right? So you can raise it at anywhere, anytime, and at any court. So any court can rules on that. So you're gonna have a very you you wouldn't have a single standard of interpretation. But this is more problematic in the country with federalism. When you have different states, you have different state has different court has a different interpretation of the same constitution until it reached the level of the Supreme Court, that where everything is settled. But before that, you can have a very confusing interpretation, different forum with different understanding of the same document. That is not good, right? Because the reason why you want to create a legal system is you want a standard, you want certain standard, you want a unified understanding of the same law, right? Um, this model is not going to offer you that. Right? You're not going to get that. Um, another another argument against the Court of Justice model is that uh, more and more, I think people regard constitutional law as a different type of law, subject of study. So it's not a pure law like a private law that we talked about last time. This is more like a public law. And as I mentioned earlier in this video clip, it's a crossroad between law and politics. So uh, to use Han Kelsen's word, I mean, you cannot be a merely legal technician to do this job. You need someone with a good political sense. And the Court of Justice, most of them are trained in a very legal technical approach. Like they are trained in criminal law, they are trained in civil law, contract, wrongful act, and all those stuff. And uh, but constitutional law is a very different lot. I mean, you can work on criminal law and contract without knowing any legal histories of them. And you don't even have to like learn like how the Roman used this law and or how your neighboring country apply this law. You can just work on it just fine, right? A constitution is very different. It requires knowledge of political history. It requires knowledge of political landscape. Sometimes it requires a lot of knowledge about comparative constitutional law from neighboring jurisdictions as well. So all in all, I mean, one argument against the use of Court of Justice is that you might not have a judge that is suitable or adequate for the job. I mean, in some countries they can do it. I mean, in the Supreme Court of the United States, like U.S. Supreme Court, I mean, the the Supreme Court is de facto a specialized court, looking more or less in specifically on constitutional issue. But in other countries, the Court of Justice, they rules on all sort of of disputes, so they are a bit more generalist when you are looking for a specialist. So there's a mismatch between demand and supply there. So right, so we are moving to a specialized court here. Right? So specialized court is something that has been proposed by Han Kelsen. He's an Austrian political scientist and constitutional theorist. I'm not gonna say he's a lawyer, he's a theorist. He works a lot on constitutional theories, pure theory of law. That's one of his more famous one. But also he's the father of constitutional court. He worked in Austria for a while before he fled to the US during the Second World War, and he taught at Berkeley to the very last of his day. Um, and his contribution here is that he proposed that the Court of Justice is not an adequate body, so you need a specialized body. So instead of looking for a generalist, Kelsen argue for for an expert. You need an expert, as I say, not an expert in law, in technicality of laws, but you want an expert in constitutional jurisprudence. So you need to have a good sense of law and you need to have a good sense of politics in order to be able to perform the job. So You don't deal with like tax law and contract law and criminal laws and IP law, intellectual property and stuff. You are specialized in constitutional law. You deal with it. I mean, this is already a very complicated matter. So you, you specifically train for that purpose. Right? So uh, and and I mean, of course, you pay extra. It costs you more resources because you set up a new constitutional body. But at the same time, I mean, you get a more tailor-made service if you put it that way. You having a unified standard because all the constitutional questions going to be concentrated in one court and one court only, and this court gonna by nature of it, you're gonna have a more standard interpretation of the same document, so that might be better for you. At the same time, you're gonna get a deadlock too because instead of like you can raise the constitutional issue in any court, right? You can raise it and the court has to refer it to a constitutional court. So more and more, I think people switching to the specialized court model, the constitutional court model, when they realize that the court of justice are very good generalists, right? But on certain issue, you need constitutional experts. You need someone specially trained for that. So we can say that in Africa, in Asia, in most of continental Europe, they adopt the idea of constitutional court more and more. So the Constitutional Court of Thailand is the product of the 1997 political reform. Let's say that before that, we have tried almost every model that I have mentioned. In 1932, the Constitution said that quite state that the Parliament reserved the right to review the constitutionality of the statutes. It didn't work. I mean, the parliament never revealed that. I mean, never declare or invalidate any laws of their own product, right? Uh, and then the Court of Justice stepped in and tried to say that try to review the case of criminal the war crime case. Uh, but then again, I mean, I think has to do with a very long period of dictatorship during the Cold War. So the Court of Justice dared not to question or challenge the government at that time because they are like military government. After that, they try to assign the Council of State คณะกรรมการกฤษฎีกา to be a reviewer of constitutionality of a statute, and I mean it worked somewhat, but I mean like 10 years and you have maybe 4 or 5 decisions. That is very dismal, right? So all these mechanisms didn't work. So 1997, we decided to go with like to get going with the like a fully fledged constitutional court as a specialized body. Uh, so you create a panel here. You get a panel of both a career judge. They get Supreme Court of Justice. They get Supreme Administrative Court. But at the same time, they say you need a political and legal expert to sit on the bench too, right? And they do what? They do constitutional review. So that is something that the 1997 introduced, and I would say it is immensely successful. I mean, in both good and bad way. We'll talk about it later, but at least I mean the legacy is still on, going on here, right? Uh, the downside, you see, this is not a court that we are familiar with. We imagine the court full of like trained judges, right? Legal technicians. But this is more, you can say this is a political court sometimes because, as I say, you get judges, like legal technicians, but you also get legal political experts. So, of course, I mean, on one hand, you get a combination of law and politics together in adjudicating constitutional case. But on the downside, it casts doubt, right? Uh, is this a legal interpretation? Or is this a political interpretation? Right. So you think, is this like a legal decision, or this is just a result of political compromise and not law? Uh, of course, I mean, the court has to deal with this perpetual tension. What does the Constitutional Court do? You see, I mean, if you go section by section, there's tons of jurisdictions of the jurisdiction of the Constitutional Court, but we can group them into three categories. Okay, so most importantly, they do judicial review of legislative power. They review parliamentary statutes. They review and rule whether the statute is constitutional or not. This could be a concrete review, like someone having a legal case in another court and raise the issue like, hell, I think this is unconstitutional, and the court has to refer it to constitutional court. But it can be an abstract review to someone realize that it doesn't look, this law doesn't look right. So they ask the maybe ombudsman or the National Human Rights Commission to refer the case, refer their concern to the constitutional court. And they do other disputes as well, right? Eligibility of a politician. So the question whether like has the prime minister reached that term limit, the 8 years term limit, right? Has the prime minister been dishonest in his office? Or the dispute whether like uh, did the election commission violate the constitution by organizing such and such election? So this is kind of a constitutional dispute that the court is asked to rule. And the third jurisdiction going to be the safeguarding the regime and fundamental values. So along the way, when the court adjudicate the case, the court is affirming or repudiating certain values. Right? So when the court is asked to do a human right case on equality, the court is actually affirming the idea of gender equality, affirming the idea of human right, affirming the idea of women or maybe non-binary, right? When the court is asking to review the case of political dissolution, the court is confirming what it meant to be a democratic regime with the king as the head of state. And the court tried to preserve that. So there's three broad categories of the constitutional court's jurisdiction. So in the next video, in the next video, we will look more closely at the Constitutional Court of Thailand, and possibly we're gonna talk about the problem of accountability of the court, right? So this is a bit of irony. The court is there to impose accountability on other politicians, on other constitutional bodies, but the court itself is now suffering its own problem of accountability.